employment movement. I'm Eilidh Wiseman, the Head of Employment at Dundas Wilson, and I'm going to talk today about industrial action and the thorny question of whether the trade unions could bring Britain to a standstill. I doubt many of you will have missed the headlines which stated that the union barons want to try to bring Britain to a standstill with coordinated industrial action, a point which was discussed by Ed Miliband in his acceptance speech at the Labour conference. One of Bob Crow's many calls to arms is quoted here on the slide. With the threat of coordinated, simultaneous, widespread industrial action in mind, I'd like to address whether the unions could lawfully shut down British industry and services in a similar way to the protests which have occurred across Europe in recent weeks. This is Mr. Crow's proposition. But we all know that what he wants to do is not quite as simple as he makes out. The law relating to industrial action, a minefield in which it is all too easy to stray from the paths of safety and legality. Not recent words, in fact those were spoken by Lord Donaldson 20 years ago in the case of Post Office against the Union of Communication Workers. Despite the passage of time, his words are extremely apposite, given the number of high-profile cases showing that strikes can be halted because of technical balloting irregularities. We've had some amusement in recent weeks where political pundits have been trying to simplify the law relating to balloting requirements for general consumption by a TV audience to explain what has gone wrong. But of course it's extremely complicated. The reality is that most employment lawyers and in-house teams who are looking at industrial action need to head to the books whenever these issues arise because they are so technical. From a business point of view, you need to understand the key legal issues, be able to respond to industrial action, understand where the opportunities for challenge lie, and what the practical impact is. So today, I'm going to take you through the basics of industrial action, the case concerning British Airways and Unite, common queries, and looking at the end with my initial question, can the unions bring Britain to a standstill? So looking at the basics first, I think this will be a useful refresher given the highly technical nature of this area of law, and also the fact that we don't tend to look at it too often. The frequency with which we will have to, however, is likely to increase in the coming months and years. The starting point is that employers and unions alike should always try to avoid a legal dispute. We should try to engage with each other and invest in the relationship. It's difficult to heal that relationship if the dispute ends up in court. However, I'm going to look today at situations where the union has decided it's time to ballot for action. It's at this point that the statutory provisions come into play. In terms of the relevant legislation, we're generally talking about the Trade Union and Labour Relations Consolidation Act 1992, and any references that I make will be to this Act unless I say otherwise. I'll use the Act's acronym TOCRA. On the screen is an overview of industrial action. There are four main steps. Is there a trade dispute? That is, does the reason fall within the statutory requirements? Are the workers taking lawful industrial action? Is there a strike or action short of strike or withdrawal of cooperation? Has the union authorised the action? Is the action official or unofficial? And is there immunity? Immunity follows if the action is protected, or sometimes referred to as lawful, and the union has followed the balloting requirements. So firstly, what is a trade dispute? Often people jump over this point to consider technicalities about ballots, etc., but this concept is fundamental to understanding this area of the law. It's a wide definition, so in practice it will cover most types of dispute that arise in relation to the employer. Some are mentioned in the slide. The definition, though, does not apply to issues where there are disputes between the workers, or where the predominant motive is a political dispute. It also does not apply to secondary action, which essentially involves calling or threatening a strike or other action by workers of an employer who is not a party to the primary dispute. So it doesn't apply in the situation of future employers. What is industrial action? There's no statutory definition. So, for instance, in the case of Tramp Shipping Corporation against Greenwich Marine in 1975, Lord Denning said, "A strike is a concerted stoppage of work by men done with a view to improving their wages or conditions, or giving vent to a grievance, or making a protest about something or other, or supporting or sympathising with other workers in such endeavour. It's distinct from a stoppage, which is brought about by an external event, such as a bomb scare, or by apprehension of danger." Action short of a strike can actually be more difficult to deal with. The employer needs to first of all ascertain that the employees are in breach of contract, and then, in that situation, demand that the employees comply with their contracts in full or stay away from work until they are prepared to comply with their contracts. In Secretary of State against Aslev and BT against Ticehurst, a work to rule was a breach of an implied term and therefore gave rise to the necessary breach of contract. As I'll discuss, this distinction is important for balloting purposes and calculating continuity of employment. Looking now at different types of industrial action, it's important to understand this distinction because it has significant consequences in relation to the union's protection, the rights and remedies available to the employer to take action, and what steps can be taken against individual employees. The first issue to consider is whether it is official or unofficial industrial action. Industrial action can take three forms, as shown on the slide. Unofficial industrial action. What is unofficial industrial action? Industrial action would be unofficial when the union whose members are taking part in the action has not endorsed or authorised it, or indeed has repudiated it. If action starts off as official and the union change their mind and repudiate it, then it will become unofficial on the day after the day in which it was repudiated. In the last few years, we have seen a distinct upsurge in unofficial industrial action. For example, last year, the Lindsey oil refinery strikes were unofficial, but the effect of this was to delay the employer's construction project by up to 6 months. According to press reports, the total cost to the employer was an estimated €100 million. The employer reacted strongly and sacked 647 striking workers. Following this, various workers in energy plants across the country walked out in sympathy. None of this was organised by the unions. Whilst no reports of dismissals from the sympathy strikers across the country are apparent, the employer at Lindsey oil refinery eventually settled this labour dispute by agreeing to reinstate all of the sacked workers, because of the concerns that the sackings had led to wildcat sympathy strikes across the country. I find this whole episode a remarkable example of the country's workers taking an enormous gamble with their livelihoods, which appears to have worked. Also, I would note that in the Lindsey dispute, the power of the media and social networking and telephone calls enabled the workers to mobilise the support very quickly and without union backing. Unlike official and protected industrial action, an employer has a wide discretion with employees who participate in unofficial action, as outlined in this slide. The employer can fairly dismiss. They can be selective as to whom they dismiss, which could be a way of effectively getting rid of ringleaders. The employer can withhold pay for periods not worked. Lockout or the use of substitute labour is permitted. There's also no restriction on employers using temporary labour during a strike or lockout, although this may, of course, inflame the dispute. The employer can demand full performance. The employer is entitled to demand full performance of the employment contract in the sense that it is entitled not to accept partial performance. Of course, this is a very legal look at the situation, and it may be that an employer does not wish to fully exploit their legal options here, given the wider industrial picture. So the second distinction to make is to look at whether the action is protected or unprotected. Sometimes this is described as lawful or unlawful, just to confuse matters. This is a situation which arises where the action is official, but the employer seeks an interdict or an injunction, which, say, for instance, states that the balloting procedure has not been compliant. Employers can fairly dismiss striking employees if the action is official but unprotected. I would just note here that selective re-engagement can cause the employer to lose their immunity. As I've already mentioned, in practice, official unprotected action is rare. Unions tend to call off an unprotected strike or one which is possibly unprotected. This happened in July of this year when the Communication Workers Union abandoned the vote after its lawyers warned that technical breaches meant that BT would probably have overturned the result in the courts. Neither BT nor the union would reveal precisely how the union's ballot might have breached the legislation. The Guardian understood that BT's Employee Relations Department had written to the union several times in recent weeks, flagging up potential problems with the balloting process. You can see how that type of activity early on can lead to a strike being called off. Engagement is key at this stage. I'd like to now take a few moments to look at statutory immunity and when the union can lose its immunity. The union can lose its protection where the balloting and notification requirements are infringed, or the purpose of the action was for a prohibited purpose, for example, the action is secondary, or if the action involves unlawful picketing. If immunity is lost, the union is vulnerable to legal action taken by the employer or a member of the union asked to participate in action, and indeed a member of the public likely to be materially affected by the action. They can all seek either interdict or injunction proceedings. Equally, damages may be available of up to £250,000 if the union has over 100,000 members. There's a sliding scale which affects the amount of damages if a smaller union is involved.